Hello, everyone. Welcome to our June webinar. I am Sophie Stalla-Bourdillon, co-director of the Personal Privacy Hub, and it's my pleasure to moderate this panel today. Today, for once, we'll speak about AI, or more precisely, some forms of machine learning models and GDPR legal basis. The background question that we will address is how to determine which legal basis is suitable for training and deploying AI models. More specifically, I have a set of 5 main questions on my desk. First, is it legally sound to distinguish between the training and the deployment phase for the sake of determining the legal basis of the processing? Second, if yes, then when should the legal basis of the deployment phase have an impact upon or contaminate the assessment of the legal basis of the training phase? Third, can a mere commercial interest amount to a legitimate interest? When? And is AI training a legitimate interest? As there is AI and AI, or better, as AI can mean anything or nothing, even sometimes mere magical thinking, it would seem logical to distinguish between types of AI, or maybe between intended purposes of AI. And for this, see the AI Act, where the intended purpose drives the risk categorization. Fourth, if the legitimate interest of the business amounts to a lawful legal basis, what does this mean for the right of the data subject to object and other individual rights? And finally, what are the criteria for determining whether the training of generative AI could be based upon the legitimate interest legal basis? And how should we handle special category data then? These questions have been addressed at different levels by different stakeholders. The CNIL, the French DPA, touches upon them in its April recommendations on AI. The Belgian DPA touches upon them in its March decision on transactional data reused by a bank. The EDPB tackled them in its recent report on the work undertaken by the ChatGPT task force. The EDPS touches upon them in its orientations on generative AI. And very recently, NOIB also touches upon them in its 11 complaints, asking DPA to launch an urgency procedure to stop changes brought to its privacy notice by Meta. And in particular, the mention that AI training is based upon legitimate interest. NOIB argues in this context that the logical choice for the legal basis should be opt-in consent. And it also mentioned an interesting distinction between defensive and offensive legitimate interest. To try to bring some elements of answer on the table, I will be joined by 3 GDPR experts. Erevan Malrou from the AI department of the CNIL, the French DPA, Prof. Hilke Huismans, who is chairman of the litigation chamber at the Belgian DPA and member of the executive committee. And finally, Pablo Trigo Kramstak, who is a researcher at LSTS, VUB University in Brussels. Time is short, so we'll try to cover most of the topics, and please ask questions in the chat or in the Q&A chat box. We'll start with the webinar with Erevan, who will present the CNIL recommendations, then move to Hilke, who will speak about essentially the March decision and a little bit also about the DPB, and then Pablo, who will focus upon a few challenges related to generative AI. So yes, let's dive into the topic. Erevan, the floor is yours.
Thank you very much for the floor, and thank you also very much for the invitation. I'm really glad to have the opportunity to discuss this really important and exciting topic with you. Can you see my screen properly? Great. So maybe I could start by introducing myself a little bit more first. So my name is Erevan Malrou, and I'm a French qualified lawyer at CNIL. Although I also studied computing science, I am mostly talking as a legal expert within the AI dedicated department that has been created a year ago now, and that is essentially focusing right now on how to provide guidance to different stakeholders with regard to GDPR compliance in the context of AI. So today, and I promise I'll get to the point of the purpose soon enough, but I wanted to start by giving you some context and some insights about the first recommendations we recently published with regard to the development of AI system. So clearly, we are seeing a gap in between compliance considerations and some parts of the machine learning community. So as a data protection authority, we intend to try and close that gap as much as possible by issuing some guidance that we try to make and draft in a way that they are as concrete, operational, and illustrated as possible, because it is generally quite easy to be understood by legal experts and privacy experts. But we really want to be understood by operational and tech people as well, especially those who are not necessarily data protection experts. So for that, we rely a lot on many different exchanges we have with a wide variety on stakeholders, both before the drafting of our recommendations and also during their finalization process, because we tend to use the process of public consultation more and more often, especially in such complicated topics as AI. So we are not yet finished, and because there is a lot to tackle, and more guidance is on the way, as I will maybe briefly mention later. But we wanted to start first with the main core principles of the GDPR, which are the purpose, which is the one I will be addressing today, of course, but also qualification, legal basis, minimization, and basically any principle that were deemed to be incompatible with the development of AI, which can be arranged and interpreted in a way that both preserve innovation and the rights of individuals, and namely data subjects. So now, and even if the CNIL is a rather large DPA, my team is not that big actually. We are only 5 people, so we could not tackle all the legal and technical challenges involved all at once. So we had to decide on what to handle first. And here is the chronological order of data processing activities generally involved along the life cycle of an AI system. At least for deep learning AI systems, because it could be arguably not as accurate for expert systems. That let's take the example of deep learning AI models and systems. So everything starts with design, then you collect training data, then you pre-process it, you train a model with it, potentially integrate it, meaning integrate this model into a system that will be called AI system, and that will be used by potentially someone else than you, and that is what we call the development phase for the first part and deployment phase for the second part. With one processing category of processing activities, which is a little in between the two phases, and that's the one in the dotted line, which is the category of processing activities involving the reuse of usage data for improvement or developing new model or AI systems. And that's a first spoil. We started with the development phase. So now is the time I really delve into the topic of the purpose, because the reason why we started with the development and followed this chronological distinction is strictly linked with the question of the purpose, and the question of how many purposes there are within this life cycle. So first, and I am aware that it will not really be news to any of you, but still I would like to recall how important and systematic the question of the purpose should be with regard to GDPR compliance, because that's the very first principle you need to respect in order to assess the overall conformity with regard to all the other principles and obligations. So namely information minimization, lawfulness as well with the legal basis we will discuss a bit later on. Again, this is the first thing you must do correctly to be sure that you ensure compliance with the other principles. So if we try to distinguish between processing activities, we see that on one side we have a provider to use the terminology defined by the AI Act, for instance. So its main role and activities will be generally to collect and pre-process and use the training data. It will be quite different on the other side for the deployer, which will also process data, but not necessarily the same, and not for the purpose of developing an AI system, but through the use of the AI system. And that's the key question that we had to come to an answer to, because the input data during the deployment phase will potentially not concern the same person, as the data subjects of the training data will not always be the persons affected by the use of a given AI system. So it is true that we could also consider that the AI system is not the ultimate goal of the development phase as well, because the final purpose will always be what is the given AI system being used to. So we try to take that into account. We try to take that into consideration in our guidance that I'll present right away. So we essentially three scenarios during the development phase. Sometimes, and that's the easy case, you already know for which case your algorithm or AI system will be used. So that's the case we could call narrow or usage-specific AI systems. In that case, we still do not consider that the purpose of this data processing to develop such system is exactly the same as the one it will be in the deployment phase, but it is directly linked, and that's the terminology we use. For instance, to illustrate what we mean by that, it will not be direct marketing personalization, but the purpose of developing an AI system whose intended purpose is the personalization of direct marketing communications. And this difference is really, really important, because on the one side, we can see that we can already tackle and apprehend and consider the final use of the AI system we are wanting to develop, but we are not necessarily using and informing the persons in the same way as the deployer will be, because it is quite different to use your data to address you directly, to send you direct communication, and to build a system that might be used on many other persons different than you. So this is the key recommendation for the very simple case. But and that is the main reason why we are having this discussion right now. Actually, all systems are not specifically designed to serve one particular use case, and especially with regard to the proliferation of foundational models and LLMs that we see nowadays, that are defined by the AI Act as general purpose AI systems or models. Because they can do a lot of things, and that they cannot be always anticipated by the developer or provider of such systems. So in such case, and this would be our second scenario, it is a bit more difficult, but it's still perfectly compatible with the purpose principle under the GDPR coming to us. So we consider that although it is true that a provider won't have to anticipate any possible final and use case for a given system, we consider that this requires to be at least explicit about two things. The first thing being the type of system or model that he or it is willing to develop, and the capabilities that can be technically considered. So for instance, for the CNIL, it is not sufficient to mention in the privacy policy that you're processing personal data to train or develop AI. in a such general manner, this statement will not be sufficiently specific to meet the requirements under the purpose limitation principle. Obviously, this will have an impact on the legal basis as well, on the overall compliance, because the wider the possible uses, the greater the risk to the interests, rights, and freedoms of the individual. So this is why we recommend, in addition to these three minimum requirements, to get even more precise, namely by specifying three more things that are not always going to be mandatory, but still. The first one being focusing on the most at-risk foreseeable capacities, potentially with regard to the categorization of the AI Act. For instance, if a computer vision system can do facial recognition capabilities, it should be mentioned and brought to the attention of the data subject, for instance. Features that are excluded by design could be also a way to narrow and be sufficiently specified as a purpose. And finally, the last category of details that could be very useful would be the conditions of the use of the AI system. And for that, we mean whether this is going to be for commercial use, non-profit research, whether it's going to be published under an open source license, this kind of conditions. And licensing and contractual terms like technical documentation and notices can have a great role into doing this and into allowing a provider to ensure that he does not have to comply with all possible use if it is in a capacity to prove that it is not gonna be able or possible to use its system for forbidden uses, for instance. And now, I'm sorry, I'm running a bit late, but we do hear a lot that the GDPR is preventing the innovation because, especially in the context of AI, capabilities as well as use cases can be discovered on the go. And for that, we think that a very good answer is already provided by the GDPR itself in the form of the purpose for scientific research that we try to define, and that could be a very good way to try and discover some capabilities as well as some use cases within a safe space in terms of GDPR compliance. So to conclude, we consider that this distinction between the development purposes and the purposes of the deployment phases are very practical and accurate. But, and there is always one but there is still one last legal and technical challenge that shouldn't be overlooked, which is the nature of the AI model. So what I'm talking about here is that in some cases, and especially deep learning models, will memorize some training data that could contain personal data and be able to regurgitate them at a later stage. So the deployer in such cases could then also be processing the training data that has been memorized within the AI model, and which challenge a bit this distinction we just made. So this is one of the key challenges we are currently facing, and on which we'll publish new content very soon. And that will be my last slide, I promise. But a second batch of CNIL's recommendation on AI will be published in French in the coming days, hopefully in the coming weeks in English, for open consultation again. And it will tackle this very specific question about the application of the GDPR to AI models that have been trained on personal data, along more detailed guidance on legitimate interest, specifically in the context of scrapping data or open sourcing data, along transparency and data subject rights issues that are also strictly connected to the question of whether we should apply GDPR to AI models and under which circumstances and context. Sorry, I've been long, but I hope this was clear enough and that you still have time to ask questions if you have any.
Yes, thank you. Thank you very much, Evan. And thank you for being very clear. So if we just say we process data for AI training, well, that's not good enough. Can you say just a little bit, a few words about what you mean by usage data? Do you include also the prompts into the usage data definition?
Sorry, I was on mute. Yes, it's not really clearly defined formally yet, but what I meant by that personally was both the input data and the output data during the deployment phase. It could also contain some meta data as well, but any kind of data that has been processed during the development phase.
Okay. Thank you so much, Evan. The audience in the webinar, if you have questions, feel free to populate the chat and the Q&A while we are speaking. I can have a look at them. Hilke, the floor is yours.
Thank you very much, Sophie. Thank you very much also to be in the Privacy Hub again, a Privacy Hub which has a good place in my heart because I did a lot for the Privacy Hub over the years, recently much less. As Belgian DPA, I think we should be much more modest than the CNIL because we don't have any yet a team really dedicated to AI. I think we should work in this direction, also independently whether or not our DPA will have a role in the AI Act. That's a different story, not for now. What I would like to do in any case is now to focus on two things. One, the EDPB task force on ChatGPT said a few things on legal basis, and more precisely, we had as authority, especially our litigation chamber, which I chair, we had the possibility to give some further guidance on the use of training data in the banking context. Let me first go to the EDPB task force that gave some good guidance on talking on how to assess lawfulness, and also we lawyers we also try to make distinctions because that's the way we can work. The only thing we can tackle technological issues is by making clear distinctions. So we all try to do it, and if it is completely in accordance with reality, it's a different thing. But this is what we try to do, and what also the EDPB tries to do in this task force, of which, by the way, I was not a member, but I recall I just recycle what is in the meantime a public document. It's useful to distinguish different stages of processing of personal data. Collection of training data, pre-processing personal data, then training prompts, as mentioned by Sophie already, etc., etc. So everyone finds his own way of distinctions, and I hope we are not too far away of what the EDPB is not too far away of how the CNIL did it. In my next slide, you might see a few elements of this document of the task force on the EDPB website, looking at, for instance, web scraping. To what extent is that allowed when you process, when you train models on the basis of personal data? The task force really looked at Article 6.1f, so this is of interest, and also on the specific requirements for sensitive data when it is talked about, and that's an important issue, I think, here, whether or not sensitive data can be used, and can you really use the instrument of the tool of web scraping to because you say that the data have already been made public. I think what the task force clearly said, made public by the data subject must be really seen as actively being made public also for this purpose, which limits, I think, possibilities to use sensitive data. Fairness, of course, always important in everything we do, in every data processing, but especially also in the processing the AI context. Transparency, accuracy, linked to this as well. And it's important also to always guarantee that data subject rights can be exercised. And that's not so evident, I think, in practice when you talk about training models, etc. The right to object, maybe, at least that's one thing which we identified in our own decision of a bank. That's on the next slide, where I focus, or I mention a case which we had decided on, a very small case in the end, but it had some reflections, and I'm very happy that our cases are found on the website of our authority. So I'm happy that the Privacy Hub know what we are doing. We had a case on where it was on building and training models, especially for personalized discounts by a bank. And there were a few legal questions that came up in the decision. It's only available in Dutch, so I try to make a short summary in English. This building and training models for this specific purpose cannot be seen as a compatible purpose under Article 6.4. That was our starting point. So if data are collected by a bank for financial transactions, you cannot say that making models for instance, for personalized discounts, it qualifies as a compatible purpose. We said that's not the case. So then you need either consent or legitimate interest. In our decision, we claimed that legitimate interest can be a proper legal basis under certain circumstances for training models. Purpose test needs to first be qualified. Also, with legitimate interest, there's always this three steps approach according to the case law of the Court of Justice. So first, is the purpose test met in being as meant as to understanding services in the light of digitization can be a reasonable commercial interest, we said. So it's for a bank, it can be useful to understand the improvement of their services, or to improve their services in light of new products, etc., etc. It can be a reasonable legitimate interest or a reasonable commercial interest. Well, I'm not going to go into the detail in the discussion, which is the fundamental discussions whether as such a commercial interest can be a legitimate interest. That's before the Court of Justice now, not for here. But in any case, we said that this can be a reasonable commercial interest. Then the necessity test. Of course, you need to analyze data, and you need to train, and you need models for training. So that's necessary. And then the more important point in the end, we said, well, how about balancing the impact on the data subjects? Starting point for this balancing test quite often is our reasonable expectations of the data subject, and that we find that's on our next slide. That we find in a different way. So the impact on the data subject must not be disproportionate and must be limited, basically. That can be the case when you use a model, when you train a model, when you train an algorithm. For instance, you cannot apply it on individuals directly. So automated decision making on the basis of that model is something which we say is not something which is not allowed. Also, it must not be possible to re-identify people. Re-identification should be excluded in these models. Another element which we found important is the indication are sensitive data being used in training models? In our case, we had a simple conclusion. We said we cannot identify whether there are Article 9 data, whether there are sensitive data. So we don't have to decide on it. But it's an important point in the balancing test whether or not Article 9 data are being used. And another thing, in theory easy, but in practice not always, is there a right to object? There must always be a right to object, but how can you object against using your data for a training model? Well, that's a question which I think is very important to look at in the future, I think. As you might remember from the slide before, is that the whole issue started with personalized discounts, which were made on the basis of these models. For this personalized discounts, in the end, we said you always need consent. There's always should also be transparency, and there should be, and that's the last point we made. Trained models cannot lead to personalized advertising, at least not without consent and not without other safeguards. So there always should be safeguards should be put in place. Safeguards, that's the whole thing. How that works, if you claim and if you take the starting point that in itself AI will be used to train models and also to train algorithms. This is more or less what I had to say on our case, leaving a bit for discussion for the rest. Thank you.
Thank you so much, Hilke. Just a very quick questions. Can you say a little bit more on the data flows at stake in this case? So you mentioned that the ultimate purpose was personalized discounts. So was it purely for direct marketing on the side of the bank? There was no external data flows, no data coming from any third parties involved in the process?
In this case, indeed, the data were only used for the purpose of the bank itself. So to give personalized discounts for by the bank itself or by its insurance, basically its insurance companies, it's a bank assurance company which works together, so not by third parties. And that's an important thing, I think, in it. Good that you ask it, so it gives me the possibility to specify that. Thank you.
Okay, and a little bit more on the assurance related to de-identification. Can you explain a little bit more what you were trying to say about reducing re-identification risks?
Yeah, well, basically, when we considered this case, we thought, well, data are being used, personal data are being used for training models, for etc., but it should not be that these new data which are used in context of AI later can be re-identified to individuals, for instance, to give them a personal favor or to send them marketing, etc., etc. So it's about the fact that you can use personal data, but you must do it in a pseudonymized way, which not easily lead to re-identification. I hope that's clear enough. But
okay, so there was no finding of anonymization in this case.
No. Otherwise, we would say if it would really be about anonymous data, then they wouldn't have this discussion.
Okay, just to be clear. Okay, thank you. And one last question on legal basis. So you draw a clear distinction between the intermediate phase and the legitimate interest legal basis that is used in this context, and then the actual offer or recommendation of the personal discounts, which is based on consent. Why is it that the final legal basis has no influence over the intermediate stage?
We tried to distinguish the stages, and we said, well, the training of models, etc., is a separate issue where it's also very difficult to give consent, basically, because what do you consent to is different than the final product for which then your data are being processed, and that's clearly about your person. If you get an offer, it's based on who you are and not about the development of the system itself.
Okay, but I assume you would still agree that the ultimate purpose could have an implication for the assessment of the legal basis during at the training stage. Yeah, if like in the Clearview case, if the purpose, yeah. Okay, thank you so much, Pablo. The floor is yours.
Thank you, Sophie. I'm going to share my slides. Okay, you can see the deck, I think. Yes, no? Okay, thank you very much for bringing to the floor this debate on this very topical issue right now. And well, I would like to, after hearing the speakers, I realized that this option for just trying to present some background information regarding how difficult is trying to enforce or comply with GDPR provisions in AI context. Probably is the best way for understanding, you know, how difficult is trying to grab this issue of AI systems and lawful basis. And in that sense, I would like to talk more about generative AI, because one of the most challenging data processing environments that probably for GDPR compliance right now. And well, when organizations develop and deploy AI systems designed to constantly collect, absorb, and process different types of information, it's crucial that they comply with data protection law. That's not a mystery. But the problem is that new AI systems are increasingly complex. Large language models and foundation models are usually trained on huge amounts of data, including personal data, non-personal data, mixed data sets of data, most of them scrapped from publicly available sources. And I think that it's important to refer to this fact at this point. I'm going to refer this later, but it's very important to try to keep in mind that contrary to the US privacy laws, such as the California Consumer Privacy Act, EU data protection law does not exclude from its scope personal data that is publicly available. And under US law, for example, there is no expectations of privacy with respect to publicly available information, which explains to some degree the transatlantic divide on privacy and data protection. And this is very important because, as you know very well, these generative AI systems, most of them are designed in the United States. And this could explain the problems that we're facing right now regarding these systems. Some key data protection principles that must guide these data processing operations are, as you know very well, lawfulness, transparency, and fairness. AI developers should limit the purpose for which data is used, minimize the amount of data collected, and ensure data is only stored as long as necessary. Accuracy and security of data are relevant too, and developers must be accountable for how they handle and process data, and embrace the broader concept of data protection by design, something that could be particularly difficult in this context. These principles should be at the forefront of AI development. But let's focus on large generative AI models. Large generative AI these models are trained to follow process and instructions and provide by understanding or interpreting users' natural language input a human-like response. And in this sense, they are computational systems designed to generate sequences of words, code, or other data, starting from a source input, call it the prompt. This is very important when we try to delve into these models. Prompt, this is a very important concept. How are these systems trained? Well, in the first stage, the pre-deployment phase, The model is trained from massive quantities of data collected from countless sources. Pertaining or initial learning data may come from bulk data sets or third-party providers, or may be extracted from vast amount of unstructured and unlabeled data stored on the web through website scraping and data mining tools, including personal information that is available on the public internet. Next, in the post-deployment phase, these systems are trained to improve its performance, and users' inputs will be used in this process. Linked to this process of customization or fine-tuning, which involves additional training of a pre-existing model, it's important that it's very complex, this phase of the customization and fine-tuning, because this involves that a new actor, a new stakeholder, is putting more information, new information, in order to train the data sets, in order to train the system, in order to produce more specific kind of outcomes. This could be is very challenging because involve situations that, in principle, were not visualized or conceived by the original developer when designing and constructing this kind of models. Well, I think that the proper way of dealing with these kind of systems is considering a multi-stage approach, and this means to understand the data processing activities in this context, that this kind of data processing activities take place in different phases with some specificities. And in that sense, when defining the appropriate legal basis for processing personal data, it's necessary to distinguish these different stages and purposes with different stakeholders participating in each phase, and related, for example, to pre-training AI algorithms, AI testing and validation, system deployment use, customization or fine-tuning, improvement of a given model, or the development of new AI services and so on. But in some way, these different stages, these different phases are related. It's very difficult to try to just separate them. In principle, it's possible to do that, but we can see that this kind of cycle in which all of these different phases are related, and the different stakeholders participating in these different phases, stages, are still involved, and their responsibility is there. Another challenge is related to AI as a service. For example, when an AI system are deployed, personal data processing shifts towards operational use. But in these cases, AI as a service models involve the continuous processing of prompts and users' inputs to enhance service quality and develop new functionalities. Developers could consider these ongoing data processing activities are as an integral part of the added value that this kind of AI services are providing, are offering. And in that sense, the question is if these kind of data processing activities are compatible with the GDPR. And this is a very hard question. Other thing that's very interesting when dealing with this kind of this multi-stage way of conceiving this kind of data processing activities is the concept of data controllers and the situations in which can exist some kind of joint controllership scenarios. The concept of data controller extends to entities that determine purposes and means of data processing. And in the context of AI, this can include organizations that deploy AI systems and those that contribute data for training purposes. And this is especially challenging when dealing with generative general purpose AI systems designed to perform a wide range of tasks, many of which may not have been anticipated during the initial development phase. And this adaptability requires a flexible approach to data processing, legal basis should be established not only for the initial use cases, but also for potential future applications, ensuring that data processing remains lawful as the AI system evolves. And this is very challenging. Systems pre-train and retrain on special categories of personal data are also very challenging aspects of these models. For example, users of these systems may, through their prompts, inputs, reveal consciously or unconsciously sensitive data concerning them of third parties. And the question is again, if these kind of data processing activities are compatible with the GDPR. A very important thing when deciding which lawful basis is adequate for this kind of data processing activities is the situation of data subject rights. Implementation of these rights in the context of AI presents unique challenges. Personal data encompass any information related to an identifier or identifiable individual, and in the context of AI, data processing includes collecting, storing, and using data to train and improve AI models at all these different levels. And the probability, the chances of, for example, inferring data through the use of these systems make all these different data processing operations more challenging from the GDPR's perspective. We mentioned before the situation of web scraping from public sources, and this in some way put a lot of tension on over control of personal data. AI models rely on large data sets obtained from websites and other public sources, and this practice raises significant concerns regarding data subjects' control over their personal information. And data subjects may not be aware that their publicly available data is being used for training AI systems, leading to a mismatch between their expectations and the actual purposes for data processing. Moreover, the original purposes of data collection are often not explicit and not limited, given that AI training can involve broad and unforeseen uses. Other challenges is data retention and data subject rights, because and in this context, we can see a lot of uncapped data retention operations, which poses a lot of problems because this kind of AI developers and data controllers usually they don't have clear retention policy regarding the data they're collecting, and usually this data is collected and stored indefinitely, complicating the enforcement of data subject rights. Another important thing that we mentioned before is the system design and the transatlantic divide. The difference in privacy and data protection frameworks between regions such as the European Union and the United States complicate the design of AI systems. Generative AI systems are designed keeping in mind the US approach to data privacy, and US regulations, as I mentioned before, tend to be more lenient, focusing on industry-specific guidelines. And this divide necessitates, I think, a careful consideration of legal compliance for AI systems operating across different regions. It's very difficult in the concept of AI systems to try to exercise effectively data subject rights. And the major reason why it's very difficult to exercise data subject rights is because it's difficult when scraping the web to identify data that is concerning a particular individual. It's very difficult for the individual to know first that their own personal data was scrapped from the web, and after that, trying to identify the data points, the nodes that are contained in this big data sets in order to exercise their rights. And in that sense, some providers, some AI developers are asking for evidence of data processing in order to allow data subjects to exercise their data subject rights, and that is very challenging in the context of big data. Finally, because I think that in order to have more time for the discussion, to debate the questions, I just want to mention that the issue of the feasibility of removing personal data from these training data sets without affecting the overall function of these systems. And the removal of personal data, personal information from AI training data sets upon the request of a data subject is big. One of the biggest challenges probably from a technical perspective. Due to the intertwined nature of data on containing these large language models, identifying and extracting specific data points can be technically complex and resource intensive. And this raises questions about, for example, the practical implementation of the rights to be forgotten in AI context without affecting the overall quality of the inputs, the outputs that these kind of systems can generate. I just want to pose these general questions, provocations, and considerations related to the use of this large language model, and in order to just emphasize how challenging they are when trying to comply with GDPR requirements. That's all. Thank you very much, and I'm open to all your questions. Thank you.
Thank you so much, Pablo. So let me ask, I guess, as a summary of your presentation, do you then welcome the report of the EDPB on the work performed by the ChatGPT task force then?
No, yes, of course, it's very good. I mean, you're identifying, these different stages that are taking place when developing AI systems. They're recognizing the difficulties, and I think that you can see clearly that they know that web scraping and AI development is very, very, very challenging. It's very problematic, and trying to conceal both elements. I think that from a GDPR perspective, it's very, very, very difficult. I mean, I don't see right now a feasible solution in order to solve this issue of web scraping, lawful basis, data subjects' expectations, and purposes that are not well defined from the very beginning of the development of the systems. That's the major conundrum right now regarding the development of AI, generative AI.
Okay, thank you for connecting the dots. Hilke, the decision you talked about was not about web scraping, but you also looked at, obviously, there are subject rights, and in particular, the right to object. Can you explain us why the exercise of the right to object in a particular case had not raised any issue?
Well, for us, that was the easy answer, because the case was not about the right to object, but we claimed, at least that's what we said in our decision, that there should always be a right to object when, for instance, a company is using its data it has for training models, etc. That's, of course, it's already difficult when a company does it and this time it was a bank or an assurance company doing it for its own purposes. It's, of course, becomes much more difficult when data are scraped, because how will you ever know that your data are being used? So it's complicated, and I think what I retain from Pablo's intervention, in my view, is clearly that the right to object, or the right to at least to for instance, retract personal data from these models is one of the biggest challenges. So indeed, yeah, I don't have any answer, but I know that this is, you can do that in a limited context when as a company you do limited activity based on AI, but when indeed we talk about these big models generally used based on scraping, then it becomes much more, even more complicated, I would say.
Okay, and in the particular facts of the decision, was there any issue in relation to the exercise of right to object?
Well, there was a complainant, that was the basis of the case, who said, you should not use my data at all for this purpose. So, and in that case, we had to explain to what extent his data could be used for this purpose. He claimed, basically, you always need to have a consent for using data for language models. And our decision was a bit more, we didn't want to limit that to consent because it would really harm innovation, and we found it a reasonable interest of a company to improve its services in this limited AI context.
Okay, thank you. One question in relation to the compatibility test, and I guess product and service improvement, and this time for Erevan. Reusing data for product and service improvement, is this usually considered to be compatible with the primary use, or is it not? And is the fact that AI is being used, is this changing, or should it change the analysis?
Thank you for these very current questions. Well, in our first batch of recommendations, we clarified a bit how we interpret the scope of the compatible tests. So to us, there's one thing that should be really not overlooked is whether the data subjects have been informed at the time of the collection of their data or not, because it will have an effect on whether the further processing is actually considered further processing, because I know it's not always very clear, but sometimes we tend to consider that a compatible test is also required when there are both two purposes at the time of collection, and that one is the primary one and the second one is an accessory, which must be compatible with the first one. So that's not how we see things. But clearly, in either way, because most of the time it will be the legal basis of legitimate interest, and so the reasonable expectation will have to be assessed in a very concrete manner. Namely, it will be very different whether we are talking about an AI provider or a provider of a service that has nothing to do with AI, that is planning on selling data to an AI provider, for instance, especially if there was no primary information at the time of data collection. So it's a very complicated question, but we addressed it first time, and we'll come back to that point on further recommendations to come.
Okay, thank you. We've got a question about possible diverging views between DPAs, and in particular whether the EDPB would have a different opinion than the Dutch DPA. In particular, in relation to web scraping, would any one of you want to react and give us some insight as to whether there is indeed consensus emerging or not quite yet?
I can say something, but not much more than a very general thing. I'm not representing the Dutch DPA. I represent the Belgian DPA, although I'm Dutch, but that's another story. I think that there's a lot of things where we are working towards convergence, and sometimes starting points are different. And the whole discussion on whether or not commercial interest can be legitimate interest now before the Court of Justice is a quite an important issue in this context as well. But I'm very confident that as EDPB, we're always capable to find solutions.
Okay, that's an optimistic note. Erevan, do you want to add anything?
Yes, I fully support that statement. In addition to that, maybe one last spoiler from my side, because we will talk about scraping in the how-to sheets about AI to come. So I think personally, and that will be the CNIL position, hopefully also after the public consultation. But that has been already stated like that in a handbook about how to share and reuse publicly available data, for instance, that it is very difficult to talk in very categorical terms about web scraping, because it will mostly depend on the purpose, on the safeguards, on the way it has been targeted or not, both before, during, and after the actual scraping operation. So I think it will be very difficult to issue categorical guidance about it. But for sure, it will be a very interesting discussion to have at the EDPB level.
Thank you. And last question, Erevan, would you give us the same answer if we were only talking about special categories of data? Is Erevan still with us? Maybe not. I don't know what happened, but then I guess that's
Sorry.
Do you want to add anything?
It was a bug on my side. It will be even more difficult for special categories of data, but hopefully we will have time to rely on some case law from the European Court of Justice for that, maybe.
Okay. Thank you so much. So once again, everything is in the hands of the Court of Justice. We'll be waiting. Thank you so much for participating to the webinar. Thank you, the audience, for staying with us this evening. And we shall see you in a few months. Thank you so much. Bye-bye.